Hello, and thank you for joining us on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder of Feldstein Family Law Group. Both myself and our entire practice focus exclusively on family law. We have offices in Markham, Vaughan, Oakville, and Mississauga. And today I'm joined by Professor Jim Phillips. Jim is a professor at UofT with the Faculty of Law and is cross-appointed to the Department of History and the Center for Criminology and Socio-Legal Studies. Jim primarily specialized in the area of legal history. Welcome to the show, Jim.
Thank you. Thank you very much for having me.
So this is a different kind of show for us because usually we're talking about what's happening in family law and things of concern for people in terms of modern day events. And today we're talking about history. And I think the history is important because I can't think of how many times people have come into my office and their perception is if adultery has happened in their relationship, somehow the person who committed adultery should be punished and they should be rewarded in the overall resolution of the matter. And when I set them straight, they're far too often very disappointed with my answers. And for our viewers, where Jim can help us is he's really going to give us the historical background of what led us to where we are today. And if you're watching it, it may help give you a better understanding of why we are where we are today, whether you think it's right or wrong. So today, begin conceptualizing how the legal treatment of adultery within family law has evolved over time. When we start at the beginning, and I understand you have a history book on that.
I do. I'm about to publish a book called I Did Not Commit Adultery, which is about a case from 1873 in Ontario at a time when you had to prove the other partner had committed adultery in order to get a divorce. There was no other ground for a divorce. And moreover, you had to go to the Parliament of Canada to prove that. You couldn't go to a court. You couldn't go to a court in Ontario until 1930 to get divorced. And when you went to when you went to Parliament, what was called the Senate Divorce Committee, all these cases were heard firstly in the Senate, was effectively a trial. They would have 9 senators sitting as a committee who were essentially the judges and the jury, and each party would present evidence, bring forward their witnesses, have lawyers take the witnesses through questions and answers, do cross-examinations, et cetera, et cetera. So it was just like a trial, but it was held in the Senate of Canada. And in this particular case, the trial lasted 12 days of hearings.
Well, that's a long trial by today's standards, never mind those standards. So what you're saying, because this is all new to me. So historically, someone wanted a divorce. They would, in essence, irrespective of where they lived in our country, irrespective of there's no plane, so they would have to come to Ottawa for the Senate committee, or would the Senate committee go to them?
So not quite. It was a different rule in different provinces. You could go to court for a divorce in British Columbia, Nova Scotia, and New Brunswick. And I could explain why, but I don't think people want to know why that was. But if you lived anywhere else, Ontario, Quebec, in the prairie provinces, you had to go to the Parliament of Canada. So indeed, if you were a resident of, even Northwestern Ontario was a very long way from Ottawa in those days. So of course, also was many parts of Quebec, and certainly the prairie provinces were a long way away from Ottawa. You had to travel by train. You had to bring your witnesses. You had to pay for your witnesses to go to Ottawa. You had to pay their expenses where they resided in Ottawa, etc. So it's a very expensive process, and generally speaking, only the better off were able to get a divorce, although that did depend on exactly how closely you lived to Ottawa.
Okay, it's interesting as I learn new things today listening to you, because I can't imagine how difficult of a process that would have been in those days. So I'm picturing now these people having to go appear in front of a Senate committee of 9 people, travel great lengths to get there to get a divorce. And then you're saying the divorce could only be granted if the person who was asking for the divorce could prove adultery on the other side. What happened to things like support and property division back then?
Well, they were dealt with separately. It was something that was often argued about in the Senate that the Senate didn't have jurisdiction to determine support and custody. There was no such thing as property division, of course, at that time. So there's no matrimonial property as such until the 1970s. So what happened on property was that each party, if they did get divorced, each party simply walked away with whatever property they had title to. And I'll leave you to guess which of the two, the man or the woman, tended to have title to property.
I can take a guess, and I'm sure it would be right. So very different than it is today.
Yeah.
So how long did that last for, or when did that stop, when people could actually go to court rather than having to go to the Senate?
Different times in different places. So it stopped in 1918 in the Prairie provinces, in 1930 in Ontario, and 1968 in Quebec.
Wow.
Because the thing about Quebec was Catholic country, and so everybody accepted that Quebec would never pass its own law giving jurisdiction to its own courts, because the Civil Code of Quebec states, in line with Catholic doctrine, that the only thing that dissolves a marriage is the death of one of the spouses. So it was always very controversial. And not until the famous 1968 Divorce Act, which introduced no-fault divorce, were the Quebec courts given the jurisdiction to deal with divorces.
Oh, so that only came in because of the Federal Divorce Act in 68 that granted no-fault divorces. So until then, they were still operating on that regime of having to go to the Senate?
Yes, that's right.
It's, I guess in my own mind, it's hard to believe that when I think of when I was born, that it was almost going on during my lifetime.
Yes, that's true. I know it's remarkable. And in fact, you said in your introduction that you're a family law firm, which of course I've heard of your firm, but there was no such thing as family law until the 1960s, right? And it was really the matrimonial property statutes of the 1970s, and to some extent the Divorce Act, which created a category called family law. In my period, and for long afterwards, people would call it matrimonial law, or family, or the law of husband and wife, or the law of matrimonial relations, but never called family law.
Okay, that's interesting. Now, so I'm going to move backwards a little bit now, because you talked a little bit about Quebec and how important the religion was in the Catholic Church in Quebec. So how did religious and moral ideologues shape the legal treatment of adultery, starting in the 19th century and going forward to when it actually got changed when no-fault divorce came in 1968?
In fact, of course, adultery was always frowned upon both socially and legally, both by Protestant churches and by the Catholic Church. So there's really no large difference in their attitudes. The difference in attitude to divorce was that Catholic doctrine completely prohibits it. Protestant doctrine thinks it's inadvisable, but did accept that in the worst of circumstances, and it should be only occasional, that divorce could be granted on the grounds of adultery having been committed. So everybody disapproved of adultery because it was seen as the most important offense against the marriage bond, and marriage was seen as the cornerstone of social stability. And it was better generally for many people. It was, if I could put it this way, it was better to live in a failed marriage than to get divorced from a failed marriage. So you just had to put up with it. Marriage was about duty and social stability, and less so about compatible, loving partners.
Well, and the other piece of that, too, is when one party owned all the assets and had control like they did at that time, it certainly created a significant power imbalance.
Yes, very much
that wasn't part of the nexus. So if I go back, we talked a little bit about what avenues existed for obtaining a divorce in the 19th century, and you've told me a little bit about why adultery was viewed in such a negative light. Was it also considered a criminal act?
Never in Canada. In some American states, adultery was a criminal act and you could be put in prison for it, but never in any Canadian province was that the case.
Now, I find that a little shocking when I hear adultery is grounds for criminal sanction. And here now, since 1968, adultery really, it's still a ground for divorce,
right?
But almost no one ever pleads it. I can think in my career, I believe I've pled adultery 2 times in 31 years. And
right.
And they were very tactical reasons why, and it really didn't move the needle at all in the case, other than somebody wanting to say, I know you were the one who had an affair with my spouse, and wanting to shame them, right, in essence. Right. So our viewers should understand very few people ever claim adultery in a divorce application anymore. It doesn't really move the needle, except it may get you eligible for a divorce less than 1 year. Now, as part of the context back when adultery was the ground for divorce, and I'm saying this more anecdotally, seeing movies, did people arrange to be caught having an affair in order to get the divorce?
Yes, they certainly did. You know, the old thing about renting a hotel room and having one spouse and the other person go into the room and hiring a private detective who would record it and then give evidence in court, etc. But you had to be careful, because adultery was divorce was supposed to be something that you had to prove adultery, but it had to be real adultery. So you could resist if you were the partner being divorced, you could actually resist the claim for adultery by arguing that the person had condoned it, or there was collusion, et cetera, because that meant it wasn't a real offense against the marriage bond.
And it's interesting you say that, because that still lives on today. Because when I do an application for divorce, you have to say that there hasn't been collusion or condonation, I think is the term in the materials, when responding to the adultery. So that language that you just mentioned still exists now in 2025.
Yes, it was put in the 1968 Divorce Act when they were to some extent building on pre-existing law when they did that. Because of course, if there could be collusion, then what you had was parties sort of voluntarily agreeing to get divorced. If your only ground to get a divorce was to show adultery, and it was okay if you colluded on doing that, then effectively you were just agreeing to get divorced, right? And we never had a notion that you could get divorced by agreement. In a sense, we now have that with irreparable breakdown of marriage after a certain period of time.
Now, the thing I remember hearing about when I was in law school, and I think a professor said it, is that back in the days of, I guess, early days of whether it's family law, when they were arguing support, one side, if you were acting for the husband, their lawyer would say, well, the former spouse was such an attractive, beautiful woman, she shouldn't need spousal support because she'll find somebody new fairly quickly. And the lawyer for the wife would tell them to look awful when they went to court, so they could argue she never could get remarried. Now, is that just a myth I heard, or is that the way court appearances really went back then?
I suspect it was probably a bit of both. I mean, I'll be honest, I haven't really studied the support issues because, as I say, Parliament wasn't considered to have the jurisdiction to deal with divorce. In fact, with support and custody. In fact, one of the big arguments that was made in the 1920s and it took 10 years of trying to get the jurisdiction given to the Ontario courts. One of the arguments for why it should be given to the Ontario courts was that the courts could deal with custody and support. They called it alimony or maintenance, not support, whereas Parliament couldn't. So as it happened, if you go to Parliament and get divorced, the divorce decree would say nothing whatsoever about custody and alimony. You then had to go to the civil court, the regular Ontario courts, to get an order dealing with those matters. So the idea was it's much more sensible to put all things into the same
When could people start going to court to say, I wanted support or custody?
Well, they could always do that. That is to say, even separate from any divorce action. So the idea of getting support, or again, maintenance, they often refer to it, was that the husband had a duty to support his wife and children. If the husband failed to do that, then, say, for example, had deserted the wife, then the wife could take an action in court to get an order for him to pay for support. Similarly, husbands and wives did have disputes when they separated over the custody of their children. Although, in the 19th century, it was overwhelmingly the husband's right to have custody. That only began to change in the late 19th and early 20th century to a regime where the husband and wife had equal rights to custody. And then, of course, it also merged from about the 1920s into the best interest of the child jurisdiction, which they now have.
Okay, so really the divorce, and maybe this is part of the reason why it was more wealthy people, was giving permission to people to be single again, repartner, do what they want to do, but the other issues could be dealt with in court.
Yes.
Okay. And what I think is interesting for our viewers is a lot of what Professor Phillips is discussing right now leads to where we are today, because today, we've heard the constitutional issue. Did Parliament have the authority to deal with support and custody? And maybe I'm wrong, but the 1968 Divorce Act was the first time that Parliament said as they had the constitutional authority to grant divorce, to deal with child support, spousal support, what was then called custody and access and is now called parental decision-making and parenting time, all started from the 1968 Divorce Act. Am I correct with that?
That is correct. And it's actually not clear to me, and I'm actually researching the question at the moment, as to exactly how that came about. Because for most of our history, up until the 1968 Divorce Act, it was considered that these issues, custody and support, were entirely provincial matters, and therefore they could not be dealt with under the Divorce Act because that was a federal responsibility. And there was an agreement, and I think it was probably Quebec sort of agreed to this and accepted this, that this federal statute could be dealt with by provincial law.
Okay, so
I don't want to get into the weeds of division of powers jurisprudence, but yeah.
Give them some understanding. We start with the British North American Act of 1867, which had the division of powers between the federal government and the provincial government, laid them out. Right. And to this day, the Divorce Act only deals with people who are married or who are former spouses to deal with custody, access, support, like I said before. And that's relief that you can claim under the Divorce Act. Under the Children's Law Reform Act here in Ontario is where we deal with decision-making responsibilities and parenting time, formerly custody and access. Yeah. And the Family Law Act deals with child support, spousal support, and division of property. And that all stems from what Professor Phillips was talking about of division of powers. And that means if you're not married and you're in a common law relationship, you're looking at the Children's Law Reform Act, you're looking at the Family Law Act as the legislation that you're going to court to deal with. Now, it so happens that the federal government and provincial government, when dealing with the child support, spousal support, and decision-making, try to make sure that the legislation is almost identical and mirrors each other. So that way, one party that's common law or married basically will get the same relief, save and except for property, because that's exclusively the jurisdiction of the provincial government and the property legislation that applies to that. In a place like Ontario, marriage really matters, because if you're married, you have an entitlement to division in that family property. Right. If you're not married, you don't have an entitlement to division in that family property, and then you're into the minefield of arguing whether you have a joint family venture, whether you have a resulting trust, whether you have a constructive trust. and that's a more expensive, more challenging process and doesn't automatically get you your equalization payment.
Yeah, but I would say very often, you're absolutely right about everything there, but I would say by now, because I also teach trust, it's very often the case that unmarried couples can get more or less what married couples can get. But it certainly is different because married couples can just automatically look to the statute that says equal division of property. Unmarried couples have to make arguments based upon, well, amongst other things, the doctrine of constructive trust.
And there are cases where people don't get the same. There are cases where they get less. And part of it, I always think of one judge I appeared in front of probably over a decade ago. And he says to me, Mr. Feldstein, these people were together for 23 years, had 2 children. She stayed home. He went to work. It resembled a marriage in every possible aspect. How much of a discount do you really think your client should get? Which is different than a couple who may have lived together for 7 years, had no children, and they both work. So as a lawyer, when we get into trust claims, we have to roll up our sleeves and I would say work harder to get there. And I remember I had a mediation about a year or two ago on this, and the husband's position was the wife didn't contribute to anything. Her position was completely different. And they wanted to say, we'll share in the house and that's it. And my pitch at the end of the day, and I'm saying this for the viewers to understand, is that when you lined up the numbers, the husband was left with about 80% of what we would have called the net family property and the wife 20%. And I said, do you really think any judge is going to look at this and go for this? Because what trusts are is their discretion. And for the viewers, they need to understand discretion means it's gray. It means a judge is going to do what they think is right. And when you're doing that, judges will first do what they think is right and then make the law fit. And because things like trust are discretionary, if in that similar situation, the husband ended up with 55% and the wife ended up with 45%, there's a good chance a judge would have said, I'm not going to do anything. This is close enough. It's fair.
Yeah.
And
it seems to me it all comes down to the extent to which the judge will feel that a particular particular relationship between 2 people who were not married was a genuine partnership, right? And whereas the Family Law Act does talk about marriage as a partnership, and therefore everything that's acquired by that partnership belongs half and half to both parties, whether or not you have in fact contributed to the partnership by going out, earning money, saving it up, buying a house, getting a mortgage in your name, or whether you've contributed to the partnership by looking after the children, taking care of the house and the family and the meals and all that kind of stuff. So there's different ways to contribute to a partnership which are non-monetary.
And the interesting thing is some provinces will treat common law relationships and married relationships in the exact same fashion for a property resolution. Ontario isn't one of them. And that really, I've often said to people, it's a question of a policy choice. Are people really, when they live common law, are they making the decision and the choice that they don't want to be married? Ergo, they don't want to share in the growth of their assets? Or is it a situation of, we now live in a society where a lot of people don't get married because they just don't feel the need to get married, live in a common law relationship, and never really gave it any thought? And should we be paternalistic and say we should be imposing these obligations on people?
Yeah, I think that also comes, as you say, it's a matter of social policy choices which change over time. And a big factor in this, in the willingness to think that most people are in a genuine partnership, even if they're not married, is the extent to which, certainly historically, and of course to some extent still, it's the woman who ends up with less, right? So this is all about kind of the status of women and the gender division of labor in our society.
Now, my personal belief, and this isn't as a family law lawyer, but if I was the Premier of Ontario, I just wouldn't even bother touching it. I think it would be too much of a hot potato, and I don't see what the upside for a politician would be to even raise this issue right now. There's no burning issue on the radar of the electorate saying this is unfair, this needs to be changed. So I look at family law for the most part is one of those areas, even though we had the significant amendments to the Divorce Act just a few years ago, generally speaking, I don't see the legislature really wanting to touch it because there isn't the upside for them politically. And I don't know if that's something that you look at, but what are your feelings on that?
Well, I think that's right. I think we have actually largely resolved these questions, but it's useful to go back. So here I am, because I always retreat into the history. But one of the things that really precipitated the changes to division of property on separation was the 1975 famous Murdoch case. Of course, you will know that case, right? But this was only in 1975, but it was a classic case of an Alberta farmer and his wife, and this is before the reforms to our law on division of property. Who 40 years she worked on the ranch, she did everything that a ranch hand would do, et cetera, and he just threw her out. There was some physical violence involved, but essentially everything that they owned, everything was in his name. So she ended up, after a 40-year marriage, of doing exactly the same kind of work that he did with nothing. And that created quite a furor because it was, in all the newspapers, lots of stories about it. And that really helped to precipitate the family law reforms of the late 1970s.
And I think it went to the Supreme Court of Canada.
Yeah.
And in the Supreme Court of Canada, they gave her a beneficial interest in that property. And that's really what created, in my mind at least, the family law concept of having a beneficial interest in the other side's assets. And that's where the genesis or the creation of all of the arguments we get for common law couples, sometimes married couples too, depending on the asset. But that really created the rights to common law spouses for property claims that never existed before that. So here we are, and we're now.
I hate to do this, but I'm a teacher, so I actually think you're slightly wrong about the result in the Supreme Court of Canada case. The point was that the wife didn't get half. Right now, in dissent, poor Alaskan and somebody else would have given her that interest, but the majority of the court didn't get it, and that was why it was such a scandal, and why it then precipitated the legislature stepping in and legislating equal division.
Well, I appreciate the correction. It's been a long time since I read Murdoch versus Murdoch, and that would probably be first or second year law school. But suffice it to say, where it led to is a place right now where common law couples don't necessarily exist with anywhere near the certainty that married couples do. And,
Yes,
and that's the challenge if you're in a common law relationship. I mean, do I think there are places that family law could be reformed in the property regime here in Ontario? Absolutely. There are certain things that we could do that would significantly reduce the disputes that people have. One of them to me is you bring the matrimonial home into the marriage and you're still living in the matrimonial home on the date of separation. You don't get credit for your deduction. There's something about that seems unfair, that if I had money in a bank account, I get credit. I have equity in a home, I don't. Another simple one that I see causing all sorts of problems for people is how we have this idea if we get an inheritance and we have to, from the day we receive it, we have to trace it to the date of separation to protect our exclusion. Nobody does that unless you're a divorce lawyer. I got divorced and I had all my date of marriage assets kept in a safety deposit box. Mm-hmm. Nobody does that. I did it because I do it for a living. Right. So I say that on the backdrop of, if you really want, if the legislature really wanted to make things simple, they should basically say, if you get an inheritance, treat it like a deduction, because what are people going to do with their inheritance? They're going to pay down the mortgage. They're going to put a swimming pool in their backyard. They're going to buy a cottage. They're going to buy some cars. And what the legislation does is it says, don't do that. Keep the money to yourself. Don't share it with your spouse, and let's create more problems in a marriage, because that's exactly what it's going to do. Right. You're married 20 years. I get $1 million inheritance. Oh, it's all mine. None of it should be yours. So I'm saying that, you've studied the history of it, and I look at where we are now. These are things that should happen, but I'm convinced they never will happen because nobody cares enough to make it happen.
Right. But I think the reason, for example, for the inheritance, and I don't have an opinion one way or the other, but I just explain the reason for it is the idea that the Family Law Act recognized marriage as a partnership and recognized, therefore, the assets that they'd acquired as part of their common partnership, whether or not you contributed to the partnership by through a financial gain or through providing services or whatever. But the one thing you can say about inheritance is it's got nothing to do with the marriage partnership. It's because of who you are related to. And some people are lucky in that respect and some people are not. Therefore, it's got nothing to do with the marriage partnership. It couldn't have been acquired by the joint efforts of the spouses.
I agree with that, but where I see the problem is in having to trace it. And if you share it through a matrimonial home or a cottage, or you spend it and it's gone, that's where I see the problem, because what you're asking people to do is counterintuitive to something that makes for a good marriage.
Right. Agreed.
I wanted to thank you for today. I found this an interesting topic and different than what we usually do. So I want to thank you because we're out of time. And I want to say to our viewers, if you're looking for assistance as part of your separation or divorce, feel free to contact us at our website, separation.ca. The next Ask Andrew show will be on Tuesday, June 24th at 12 noon. If you have any ideas for future shows, please email them to us at info@Feldstein Family Law. And thank you for watching.
Thank you very much for inviting me.